Okay, there we go. Okay, guys, welcome to our third class. We have a few things to go over beforehand. So again, these classes are being recorded for you. So if you have to leave the class at some point or anybody who misses it, I always post them on Moodle for anybody to watch. So it'll be there for you to go over at some point, even if you want to, for instance, review it for the purposes of the midterm and the final exams. All the content is here and they're being recorded, obviously. So there we go. I sent everybody an email in the last couple of days, basically advising that there is a recorded, an asynchronous lecture that I posted on Moodle yesterday. It is, I'm still admitting people here. It is a lecture on Indigenous governance, so it's there for you to watch. It actually was a lecture that I gave in one of the last classes in the winter semester in a treaty relations course that I was teaching. But it was a good lecture that gives you a good deal of the background on the creation of Indigenous law to some degree within the terms of treaties, and particularly with respect to the United Nations Declaration on the Rights of Indigenous Persons, which is in Chapter 3 in your text, which hopefully you've read. And there's a lot of detail in there. And in fact, as you can see, one of the breakout questions tonight deals with UNDRIP. So if you're assigned to that group, hopefully you've read the materials and seen the lecture in that regard. And I also sent everybody an email today basically saying that for the purposes of participation, so as you know, everybody gets an 8 out of 10 for just coming to class tonight. So all 26 of you that are here, that's great. But unlike last class, which I called upon everybody to talk about their film studies, we don't have that for tonight. So I thought I'd ask if anybody wanted to make any comments or ask any questions regarding the recorded lecture on governance. Now, to do that, just in case you weren't aware of this within the Zoom kind of meeting, there's a number of ways that you can come to my attention if you want to have something to say. The first way is if you go to down at the bottom of your screen, there should be a tab that says participants. So if you click on that, it should give you the option to raise your hand. So if you click on that, I will see that and your name will come up. So I will call on you when you raise your hand. The other way, obviously, is just to speak. If you speak, then you come up on the screen. That's the way Zoom works, back and forth. So I can obviously respond to you in that way. And the last way, you'll see also on the bottom of the screen, there's a chat button. And some of you have used this before. We used this very briefly last day. So if you click on that, you can type in some kind of message. It would go out to everybody in the class, but I'd certainly see it. And if it was a question, we can certainly discuss it. So having said all of that, is there anyone in tonight's class who wants to make a comment or ask a question with respect to the lecture that I posted on Moodle yesterday? Oh, all right, Joy. So Joy's got her hand up. So
hi.
Hi, Joy.
Sorry, this is in regards to, anything with comments to the Indigenous, sorry, what was the chapter called? Indigenous self-government, correct? Yeah, so something that I was sort of interested in knowing is how sort of residential schools worked into like the legal system of that. Because I know, in 1982, they had sort of proposed, self-government of like them being able to do that, but then yet residential schools, were kept going on until the late 90s. So I kind of was just intrigued by sort of how that intertwined with Canadian law.
Okay, well, I mean, you guys I'm sure you guys all know that and it's a really relevant question, that Algoma is actually built on the site of a residential school. And hopefully at some point you've all taken the tour of the facility, through the Anishinaabe office in that regard. It's a really good tour. But, but when it comes to governance, I mean, residential schools were put into place in the 18th and 19th century, basically in Canada. It was a contract between The federal government now, as we talked about this last day, the federal government has jurisdiction under Section 9124 of the Constitution Act to have jurisdiction over Indians and lands reserved to Indians. So the government of Canada took upon itself to create essentially an industrial school system across the country. And what they did is they did it in partnership with the prominent denominations, religious denominations in the country, the Roman Catholic Church, the Methodist Church, which is now the United Church, the Anglican Church. And so, for instance, the residential school that Algoma sits on was run by the Anglican Church of Canada, which is the Church of England. That's what it's called. So that was established, and Joy, you're quite correct. The last residential school didn't actually stop operating until 1996. But by the 50s and 60s, it was pretty clear that the public had actually become aware of how, in fact, terrible they were. I mean, the whole premise behind them was that when children became of the age of 5 or 6 years of age, then the Indian agent, so all First Nations who basically were on reserves had an Indian agent who basically dominated their existence. You couldn't do anything, including relieving the reserve, unless you got the Indian agent's permission. So that's the kind of control they had. But it was clearly a policy, and one that would lead to punishment of the parents if they didn't allow for their children to go away to these residential schools. So they would go away to the schools, they would get there, and they would be anglicized to a great degree. Their hair was cut, their clothes were burned, they were put into white man's clothes, they were given white man's names. They were, under no circumstances were they allowed to carry on with any kind of cultural, have any cultural edifacts or cultural practices or religious practices. None of that was allowed under severe penalties, and they were always going to be, for the most part, corporal punishment. But it took 150 odd years basically for white society in the 1950s and 60s to come to realize how terrible they were, and they started to be closed down. But remember that, and this isn't by any way any kind of a justification, but history is a very subjective kind of thing, even though you would think history is very objective in that a fact is a fact is a fact. It's not. History is subjective, and it tends to be written by those who have the power to do so. And so, when residential schools were established, a century and a half ago, they were done on the premise that they were taking these essentially savage children and taking them and making them white, or as close to white as they could be, in order to better succeed in a white society. So, those members of the church and the federal government who basically ran this system actually believed that what they were doing was the right thing to do. Obviously, with the lens of history, we now know it was a terrible thing to do, but that wasn't obviously the predominant thinking of the day. So by the 50s and 60s, they started to be dismantled. But having said that, they didn't dismantle, the Canadian society didn't dismantle them without something
they have
else.
like the 60s scoop?
That's exactly where I'm going, yes. So they didn't dismantle these schools without replacing them with something which was the 60s scoop, which was essentially now the provinces coming into the picture within the welfare scheme, and then taking these children away from their families and basically adopting them out. And they tended to do this and send them a long way away with very little records of where they had gone. And so it was a very widespread advertising campaign in Canada, the United States, in Europe, to adopt a pretty Indian child. That's kind of the way it went. And that was a 60s scoop, and that went on for almost 20 years, 60s and the 70s. So it's really only been the last 30 years that all of those kinds of things are now in a proper perspective. And from a government point of view, they now realize, now both provincially and federally, that obviously doing what they did was clearly a function of systemic racism. and something that obviously, you know, can't be supported, and now, of course, needs to be responded to, and with apologies and compensation for the most part. Okay, does that answer your question, Joy?
Yes, yes, thank you very much.
All right, so Georgia's got her hand up. This is working, actually, so what do you know? So Georgia?
Hi.
Hi.
I thought it was interesting the second part of section 15 of the Constitution that white people can be discriminated against if it's for the benefit of those who are traditionally discriminated against.
Yep.
And I didn't know that was a thing. And I was just wondering if there's any examples of that actually happening that
Lots,
you could.
lots of them. 15.2 is called the benign discrimination. It's of the Charter, so the Charter is a schedule to the Constitution Act. Section 15.1 is the discrimination clause in the Charter that basically says, and you got to remember this was written in 1982 and hasn't been amended since then, but it was written basically much along the lines of the United Nations Declaration of Human Rights, the International Covenant on Civil and Political Rights, various human rights codes. Ontario has a human rights code. All of them basically say the same thing, and the Charter, you know, likewise says that within the jurisdiction that the Charter applies, which is government activities that affect the citizens, that there can't be discrimination based upon race, sex, gender, and what have you, creed, color, all those kind of things. It's a fairly limited list, and it's been expanded by the Supreme Court, but in writing, that's what it says. And so you can't discriminate on those grounds, but what 15.2 says is that if you are a group that has been traditionally been discriminated against based on those grounds found in 15.1, then you can get the benefit of discrimination going back. As in, you can benignly be allowed the benefits of having discriminatory practices that put you into an advantaged position as opposed to a discriminated position. And this to a great degree was an offspring of the 1960s Black rights movement and affirmative action. So the way affirmative action worked in the US in the 1960s, and this is exactly what this is in theory, this is just an example, if a white man and a black man applied for the same job, and they had exactly the same education, and they had exactly the same work experience, so they came to the competition for this job virtually equally, then the effect of 15.2 and affirmative action in the US was that it was perfectly permissible and in fact encouraged to hire the black man because he had traditionally been discriminated against based on race and or color, right? And discriminate, so discrimination would be allowed to benefit the black man over the white man. And the white man was clearly being discriminated against in that scenario, but that's what affirmative action does, or benign discrimination does. It allows those who have been traditionally discriminated against to, in fact, get the benefits of discrimination in their favor. Okay, is that
Yeah.
good, Georgia?
Yeah, thank you.
Shivani, your hand up?
Yes, yes. So basically, because Canada adopted the common law system, so a constitution was imposed, right? So for the indigenous people, being that they self-govern themselves, where are their laws written down?
Where are their laws? I'm sorry.
Where do they write down all their laws, like to govern themselves?
In indigenous laws, basically, for the most part, are oral. All right, always have been oral. Most history and record keeping for indigenous peoples is part of an oral society. So the laws that are intrinsic to how tribes and clans run themselves and interact with each other is passed down from generation to generation. So it doesn't basically conflict, word for word, obviously, with what was imported at the time of Confederation, which was the importation of the laws of England at that time. But having said that, I mean, interestingly, and it's mentioned in the recorded lecture, but doesn't say a lot about it, when King George III in 1763 basically made his royal proclamation with respect to how British society, and North America became British North America in 1761 after the Treaty of Paris, which France said, goodbye, we're out of here. So the French left North America. So King George III basically in 1763 said, look, you know, we have to treat these peoples fairly. And so Senator Murray Sinclair, very, very famous Canadian Indigenous scholar. He was a judge in Manitoba. He's now a Canadian senator. He calls the Royal Proclamation the Indian Bill of Rights. And what it basically said is that it said a number of things. We're going to talk about them tonight. But one of the things that it didn't do when it created a very, very large swath of territory in North America, mostly in what would become later the United States. Remember, this is prior to their independence. But you know, it created an Indian territory where he didn't impose English law. He basically left those who were there to govern themselves as they had always governed themselves, which was really, from a political point of view, a very important kind of thing, because there are lots of political theories when countries come and land on the shores of other countries or continents. You know, there's all kinds of theory about what they do with respect to the laws of settlement, the laws of colonies, and what have you. And what Great Britain decided to do was to not impose their law to the Indigenous peoples in those territories, which was, to the great degree, almost all territories that hadn't been overrun by the colonists within the 13 colonies in the U.S. So having said that, now, when it comes to what's Indigenous law today, that's a whole different matter. You know, it's something that, you know, Indigenous peoples now recognize that, in fact, their way of life and their court systems that they want to put in place and what have you, they now have to be in writing. You know, they recognize that to be able to operate in an English law system, even though it's a parallel law system, it has to be in writing and it has to be done so everybody knows what the rules are. Okay. Anything else I can tell you? Does that answer?
Yes, thank you very much.
You good? Okay. So I have a hand up from OJW. I'm not sure who OJW is.
That's all right, Robinson.
Oh, all right, go ahead.
Yeah, so my question falls in line with Chavonet's question, but from a different angle. I'm thinking the idea of Indigenous self-governance, my interpretation from that, and also from your lecture and from other readings, is that some form of their old traditional law and lifestyle prior to European settlers. That's part one. How far are we, or how close are we from achieving that? Barring to achieve that, we'll then need some amount of constitutional reform and greater acts of perhaps reopening the constitution to facilitate that. Sorry, Miles. How far off are we, or is it even possible based on today's dialogue?
Yeah. Here's the thing, and again, it's part of the recorded lecture. It's, you know, Indigenous governance or self-governance, self-determination, all those kind of things is very much on the table and is very much a part of what is now contained in what are called modern treaties, treaties that have been put in place since 1975, since the James Bay Cree modern treaty in northern Quebec. And so when modern treaties are negotiated, they basically almost always have terms with respect to self-governance, which means that they basically become, and it's a rough comparison, but they put in place very much what is like a municipal system of law, like the city of Sault Ste. Marie has a mayor and council, and even under the Indian Act, where you have bands. A band, by the way, is a white man's term. It's Indian bands, where they have chief and band councils. Although they are a very diminished form of self-governance. When you have these modern treaties, the territories basically take the position that the Indigenous peoples who sign those treaties, for the most part, will be able to have control over pretty much everything that is important to them: their education, their healthcare, their welfare, all those kind of things that have formerly or previously were provided by provincial governments or federal governments are now provided internally. And the modern treaties also usually contain large amounts of money in order to make that happen. So one of the very largest modern treaty in 1990-91 was the creation of the territory of Nunavut. So Nunavut is our third territory. It was cut up from what was formerly the Northwest Territories. So it was cut up and actually became the larger part of what was of the territories. And so Nunavut was created as a function of a modern treaty. It is, for all intents and purposes, a self-governing territory. Over 80% of the population are Indigenous. They're Inuit, which are basically Indigenous peoples living north of the Arctic Circle. And so they run the government on a but it's a little different. They run it not within their own government structure, but in a territorial government structure, just the same kind of structure that, where they have a premier and a cabinet, just the same as Northwest Territories and Yukon have. So it's as close to a Indigenous government model that we have that is comprehensive. It covers a great amount of territory of Canada, includes a lot of people, well, relatively speaking, a lot of people when you're talking about the Arctic Circle. But yeah, and then going forward from there, we have Section 35 of the Constitution of 1982. And Section 35, and we're going to talk about that tonight, is very important because it is what's called the open box within which all the levels of government in Canada, primarily the federal and the provincial governments, can work with Indigenous parties to make way for true self-governance, and what that is planned to be. And it was hopeful that Justin Trudeau's Liberals in 2015, when they took power, would bring this about, but they really didn't. They're looked at rather poorly in this light. But there's still 3 more years of this government going forward. Maybe it's a minority government. But having said that, it's the provision in the Constitution that will allow for self-governance, and the thought, of course, is that it will replace the Indian Act. Indian Act's been in place since 1876 and is incredibly paternalistic and systemically racialized. So that's the plan. So yeah, Orette, you have what was existing, for centuries and centuries before, but the future now is really Section 35 of the Constitution, and I actually teach a 4th year Constitutional 3 course just on that, pretty much on that section of the Constitution. So that's where it's going from there. Okay, Tyler.
Hi. Yes, actually, that kind of answers the question that I had a little bit. I was just curious, and I was looking for some of the most recent developments on self-governance, and I had come across what was called. I'm sorry, one moment. I have it here. I had come across what was called the Indian Act Amendment and Replacement Act. I was wondering if you are familiar with this and could elaborate on this or any other most recent developments. This was cited in 2014. And I'm just curious again.
I don't, Tyler. I mean, I'm not familiar with it, probably because it was well, I know it was promoted by the Harper government, but it really wasn't intended to replace the Indian Act. It was a political proposition and not really a legal one.
Okay, and I was just curious on some of the most recent developments on self-governance, and you had mentioned Section 35 of the Constitution was one of the most relevant things today for that.
Yeah, the Section 35 is the provision of the Constitution that will, as a function of making it more robust and allowing for self-determination, it will be the provision that relied upon to, in fact, revoke the Indian Act, which was tried before, and we'll talk about this tonight, back in 1969 by Pierre Trudeau. So we'll talk about that in the lecture tonight.
Okay, thank you.
Sure, Tyler. Valerie?
My internet's been kind of in and out, so let me know if you can't hear me.
So far, so good.
Okay. I guess my question is more towards the missing Indigenous women that were disappearing. You're talking about self-governance and the federal ruling, like who's in control of what? Is the federal government not doing their part? Who's responsible at this point for working towards resolution for the missing Indigenous women?
Yeah,
What-
it was a royal commission. It was put in place by the federal government, but with the participation of all the provinces and territories. So, from a governance point of view, again, clearly the federal government has responsibility for Indigenous peoples in the country. The report has been released last year with a number of recommendations, but what happened is that the report was released, and then it came time for a federal election. So nobody was paying attention to it, obviously, during the course of the federal election. And then, shortly after the Liberals were elected, because it was a minority parliament, they weren't called back into parliament for a considerable period of time, and then COVID hit. So the federal government, really hasn't had a chance to put any teeth into the recommendations for the MMIWNG inquiry. But that's still to be seen. Lexine?
Oh yeah, definitely. I'm here. All right. Based on my readings, I found that the Native Americans in America, they basically have domestic dependence and sovereignty. So, but you also said that it is not applied to Canada. So I need a bit more information on that.
Oh, the comparison between the Americans and Canadians?
Yeah.
Yeah, there are the Navajo and the Cheyenne. Some other tribes do have a fair bit of self-determination and governance in the United States. That's been granted to them by the federal government there. And so it's, in some cases it's working quite well. In some cases it's not working at all. But it is a good model for us to look at to see how it's done, because the Navajos, for instance, have complete control over their territory. So you can't come into their territory without their permission, and you can't do anything on their territory without them knowing about it, which is more control than a democracy has to some great degree, but it's probably necessary so they can make sure they know what's going on in their territory. And they're funded by the federal government as well, or casinos. Casinos are a much bigger generator of income for Indigenous peoples in the U.S. than they are in Canada. Although in Canada, they are, if you have a band with a casino in your territory, you tend to be a pretty well-off band. That's just a reality. But in the States, most casinos outside of Vegas, obviously, and Atlantic City, most of them are on Indigenous territories. But yeah, they have models of Indigenous governance that in many respects are more advanced than ours are.
Definitely. So what would you say is the main issue why it is limited here in Canada as it relates to the United States?
Well, again, we're going to talk about this tonight. Oh, I can tell you about it now. So it's a different system. I mean, our system of dealing with Indigenous peoples, although it was highly discriminatory, and I mentioned this last class, it was incredibly disrespectful, basically as a function of the way that Johnny MacDonald decided to push across the Prairie provinces to build the railway to the Pacific Ocean, and to basically have treaties negotiated that were fundamentally contrary to the benefit of the Indigenous people signing them. But the difference is that in Canada, at least, as a function of what were then called the Northwest Mounted Police, now the RCMP, it was done peacefully. Apart from Louis Riel and the Métis uprising in Manitoba, apart from a couple of things like that, the Canadian, as in the white Canadian society, developing this new country of Canada after Confederation, was done on a fairly peaceful basis. That's not what happened in the United States. The United States basically conquered the natives. That it was with the use of the army. So totally different approach. Custer, George Custer in the 1870s, all those kind of things. The acquisition of territory in the U.S. was done by slaughtering native tribes more than anything. So a totally different political schemes in place. So it's really not comparable from that point of view.
Okay, thank you.
Sure. Great, guys. That was great. That was actually better than I expected. Anybody else? All right, you still have your hand up. Is it still up because before, or you want another question? Are you good? Oh, there, lowered hand. All right, guys, super. Listen, I really appreciate that. That was great. So let's move on to the lecture. I've recorded everybody who's talked, so you're going to get extra marks for participation. That's how it kind of works. So you'll see that. I'll send out a poll after the class, and you'll get those grades. So what I'm going to do now is I'm going to share with you the PowerPoint for tonight's lecture. All right. So basically, we're dealing with treaty. We're dealing with treaties, essentially, which treaties are the way that the English government, again, the Canadian government at the time, basically acquired most of the territory that became Canada, and it did it on a non-aggressive basis. All right, they were negotiated, although they certainly weren't negotiated to a great degree in a fair manner, and there's still lots of litigation ongoing as a function of some very historical treaties, including, for instance, the Robinson-Huron Treaty, which is the territory that we're in now. But in any event, so treaties, let's go back to the fundamental premise. They basically were the fundamental mode of negotiation to establish Indigenous peoples' rights over their territories, including environmental protections. So those territories that they ended up having as a reserve, which was their right to occupy the lands. Reserves aren't owned by the bands that are on them. The bands, again, created under the Indian Act of 1876, but they have a right to possess them. The rest of the territory becomes Crown lands. In reality, almost with some exceptions, the vast majority of Canada is treaty territory. So, and you and I and everybody else who are on lands that are in effect because of treaties, are treaty people. So, every building, every business, every road, any other activity that takes place, including anything within Sault Ste. Marie and the environs, are possible because of a treaty. So a treaty is a mutual agreement between nations, right? And that's really important to keep that in mind when treaties were first entered into. And now we're talking about the peace and friendship treaties back in the 16th century, when English and French and Spanish and Portuguese explorers came to these shores. When treaties were first entered into with the Indigenous peoples who were already here, who had been here for 10,000 years, they were treaties between nations, as in, the government of England was entering into a peace and friendship treaty with this entity, these Indigenous peoples that were a sovereign entity in their own right. So that's important to keep that in mind. And so in 1763, as I mentioned a little earlier, the Royal Proclamation was issued by King George III, which recognized the pre-existing rights to the lands of Indigenous nations. Right? He did that at that time. Again, 2 years earlier, Britain had acquired all of North America as its territory, but he also did it because up until that point, from a century before, or 2 centuries before, when these peace and friendship treaties were entered into, where Indigenous groups were seen as sovereign nations, over the course of time, as white settlers and colonizers came to the shores of North America, as the more people came that basically, created these colonies, the colonies being the 13 colonies in the US and the 4 colonies that became Canada. The more that they came, the more of the power that shifted, and the more often than not, they would go out and acquire territory from Indigenous peoples for next to nothing, or trade very little value. So they were basically stealing these lands to a great degree. And what King George did in 1763 is he put a stop to that. And he basically said, and importantly, part of the proclamation was that no one could enter into the acquisition of Indigenous territory except the Crown. Okay. The proclamation also established that the Crown had a fiduciary duty to Indigenous peoples. Anybody want to give me a quick definition of what fiduciary is? Some of you know this. Tyler, What's fiduciary? Michael. Michael Webster.
Can you hear me?
Yep.
A fiduciary duty is where the person who has that duty needs to act in the best interest of the person who they have the duty to.
Excellent. Thank you very much. So that's right. And we're going to talk more about this later in the class. But that's the kind of policy that King George III put in place. So a very enlightened policy. Now remember, however, that it was a declaration. It wasn't a treaty itself. So it was just King George in that particular year, 1763, declaring that these are the policies that he wanted to see in place in what became British North America. Now, of course, he did that with the concurrence of Parliament. Matter of fact, it was clearly Parliament, you know, the political leaders in England at the time who actually came up with this declaration, but King George, being the head of state, is the one that basically announced it. But to make it actually, take it from a policy to being a law, the Treaty of Niagara in the following year, 1764, 2,000 Indigenous chiefs came together to meet with the Crown representatives and signed the Treaty of Niagara, which basically incorporated the Royal Proclamation, all of its terms and its policies, into law. Right, so it became a statement into basically an act of Parliament. Again, this is like I said earlier, settlers could not occupy Indigenous lands without an agreement between the Crown and Indigenous peoples, and that's still the law today. Nobody can acquire Indigenous territory if it isn't already the function of a treaty, unless it's the Crown, the federal Crown for the most part, right? Because again, Indians and lands reserved to Indians is constitutionally a federal responsibility. So that was put in place in 1763, and it's still the law today. So, you know, that was to put an end to settlers and colonizers basically ripping off, you know, Indigenous peoples and their territories. Historically, it was believed that again, this reflects back on the early history, that the British and before that the French would not have entered into treaties at all if they didn't consider the peoples they came into contact with as being sovereign in their own rights. That's a really interesting concept in the 1600s and 1700s, because, for instance, Australia, which was developed for very much the same time as Canada was, again, as a British colony, they took the position of, when they came to Australia, and again, Australia was full of Indigenous peoples. They called them Aborigines, which is a derivative of Aboriginal, and the Maori in New Zealand. But they came across these people and treated them totally different than they did here, and it's a bit of a mystery why they did that. So the policy they put in place when they arrived in Australia was one called terra nullius. Anybody want to take a run at what that is? Okay. So terra nullius, it's Latin. It means there's no land here, nothing on the land, which basically meant that when the government the British government went to Australia, they took a position that we don't recognize anybody as having any rights here. So these Indigenous peoples don't exist. They're ghosts as far as we're concerned. And they developed the colony of Australia, with British rule, without any regard whatsoever to the Indigenous peoples. And that obviously, over the course of time, has come back and bit them big time. I was at a conference in Australia about 1.5 years ago where a lot of this was the conversation, because, a lot of Australia has 5 states, New South Wales, Victoria, what have you, the territories. But, they are now, at this point, looking at entering into treaties. The very first treaty in Australia didn't take place until the 1990s. And it was only dealt with one very small tribe in a very small island north of Australia. So, the big states in Australia are in the process of negotiating treaties, what we now call modern treaties, right now for the first time ever, which is a diametrically different approach that we took. So for whatever reason, the British colonizers in British North America, when they came here, they decided that, they in fact recognized the sovereign nature of the people who were here and decided that they needed to negotiate treaties in that regard. So, that's kind of a cool dichotomy between the two places. Having said that, however, over the course of the last 150 years, when treaties really started to be entered into, these are treaties beyond the ones where peace and friendship. These are the ones that actually dealt with acquiring territory. So, what the Canadian government has done over the last 150 years is that, again, as a function of the Indian Act, they banned Indigenous culture. That's again a reference to residential schools, suppressed economic activity, forced relocation. When you create a reserve, it's the federal government who chooses where the reserve is going to go. It didn't tend to go on the best lands in the territory. It tended to go on the worst lands in the territory that were basically undevelopable. So that's kind of the way that these things worked out. Lands were dispossessed. Again, assimilation. Residential schools are assimilation. All those things are evidence of breaching treaty rights. So we have a really, we being white society has a really terrible reputation on how we've lived up to terms of the of treaties. The rights in the Royal Proclamation were in fact affirmed in the Constitution in 1982. So that's incredibly important. Likewise, we have rights in the Charter. So Section 25 of the Charter basically says that the guarantee in this Charter of certain rights and freedoms should not be construed so as to abrogate or derogate, which means move away from any Aboriginal, treaty, or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including any rights or freedoms that were recognized by the Royal Proclamation. So there we go. We now have this document that is now 250, almost 260 years old, that has been constitutionalized in our Constitution, and subsection B, any rights or freedoms that now exist by way of land claims or may be so acquired. So that's really important. It's important because, clearly when you put these things in the Charter, or Section 35 of the Constitution of 1982, when you put these things as part of constitutional documentation, we have no documents that are that exist that have more weight, with respect to the laws that are enacted. Michelle, you raised your hand. Michelle?
Yeah, sorry, just give me a second. I'm trying to unmute myself. I have a question. How come when the Royal Proclamation, it states that King George III didn't want to treat with Métis because he considered them half white, and now we're treating with them. Well, I don't know if we have treaties with them, but I know out in BC they have land and things like that, whereas in Ontario they don't, and in Saskatchewan they're just developing those rights for land. And only status First Nation people are able to get land under the federal Royal Proclamation. How come it was changed in 1982 under the Constitution Act?
The distinction between those peoples who are First Nations, which are those who are subject to treaties or entered into treaties and become members of bands, those who, for instance, are Inuit, which are those Indigenous peoples in the Arctic. Those peoples who are non-status, who basically are still Indians under the Constitution, but don't have status under the Indian Act, and Métis. The distinction between all those different categories of being Indigenous is really interesting and to some degree beyond this class. But I can tell you that the evolution of the treatment of people who are Métis is really interesting, and in fact, the way it originally worked is this, and it's the converse of what's happened now, is that Métis clearly were the combination of hunters and trappers that originally came to these shores with Indigenous women. That was the plan. Originally it was French, hence the word Métis is a French term, but I can tell you far and wide, the vast majority of those peoples in Canada who are now Métis are of Scottish descent, because the French were pushed out to a great degree. The Hudson's Bay Company took over in the 1700s and basically acquired Rupert's Land, which became 3 territories and 3 provinces of Canada. Manitoba, Saskatchewan, and Alberta were all owned by the Hudson's Bay Company. And their policy was for their trappers to go out and propagate, right? That's, go out, you want the comfort of women, but we want you to, create as many little Scots as you can. So most Métis have Scottish descent. Originally, the reason that Métis weren't dealt with in the Royal Proclamation is because they were seen as white and not Indigenous, right? And Métis, in the early days of treaty making and Confederation, were allowed to own lands. right? So, and the reason was is because, and in particularly in Manitoba, where there was a great Métis, basically development as a function of Louis Riel, but Métis were seen by the Canadian society as being better than full status Indians per se, because they were white, right? And then so, but what's happened over the course of time? So in the last 50, 60 years, what's happened, because Indigenous rights have evolved and have matured to a great degree, it's now the converse of that, where in fact Métis, if you're relying upon that status for your indigenousness, it's looked at as less of an Indian than somebody who had full status as a First Nation now. But having said that, it's a function of the Daniel's decision in the Supreme Court of Canada in the last 5 years. Métis, non-status Indians, and Indians being First Nations are all constitutional Indians. They all have to be treated the same.
So my next question is, are the Métis covered under the Jay Treaty, or is that just status natives?
Yeah,
the Jay Treaty is with the United States of America.
Métis weren't under the Jay Treaty, no.
Okay,
But
so it's just the status.
What would have been considered, it was called full-blooded Indians at the time.
Oh, okay.
Full-blooded Indians is what everybody was, which is what England was dealing with for the most part, and the Canadian government was dealing with for the most part. But having said that, and this is part of the Daniels decision in the federal court and the Supreme Court. Historians have basically, when they did their analysis, basically said, look, in 1867, at the time of Confederation, which was really important for defining who is a constitutional Indian in the British North America Act. In 1867, it was historians' belief that there probably wasn't a full-blooded Indian existing in Canada. That there wasn't an Indian in the country that did not have some white blood in them, right? And so that went a long way towards the eventual finding 90 or 110 years later that Métis were in fact as much a constitutional Indian as were those who belonged to First Nations. So it's a whole lecture on its own, other than tonight. But that's the thing, right? They have always been treated differently.
Yeah, thank you.
Rochelle, okay. Okay, so back, so this is the charters, 25 subsections A and B. All right, again, we have the Constitution Act of 1982. And again, this is section 35. So we've talked about that a lot already. So what it says is as follows: the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So that's constitutionalizing their rights. And in section 35, it says that Aboriginal peoples include, again, this is constitutionalized, Indian, Inuit, and Métis. So there you go. So it's Métis are in the Constitution. They're not in section 9124 of the Constitution of 1867, right? This is Constitution of 1982. It's hard not to confuse you with that, but that's the way it is. But that's what the Daniels decision did. The Daniels decision basically said, section 9124 of the Constitution, section 35 of the Constitution, basically all of it means the same thing, that for the purposes of the rights of Indigenous peoples in Canada, it doesn't matter whether you're full-blooded, the section 6.1 Indian Act, First Nations person, section 6.2, which is status as well. My son-in-law is a 6.2 from Batchewana. So it doesn't matter whether you're a First Nation, or you're a Métis, you're Inuit, or you're non-status, which means you're Indigenous, but you've fallen out of the formula that takes place in section 6 of the Indian Act, which is a blood quantum formula. It's we're one of the only countries in the world that still does that. Some parts of the states, for instance, the Navajos, still do a blood quantum for the purposes of protecting their tribe. All right, we have an Indian Act, a blood quantum that basically determines who has status and who has a status card. And, the status card entitles you to certain things like, post-secondary education being covered by the federal government, and some tax exemptions and what have you. But anyway, the long and the short of it is that no matter what your source of Indigenous, sources come from, you are an Indian in the constitutional sense of things. All right. Section 35 also says, for greater certainty, treaty rights include rights that now exist by way of land claim agreements or may be so acquired. So that's really important, in our discussion, because what that means is that these comprehensive land claim agreements, which are now parts of modern treaties that are being negotiated, they're constitutionalized documents now, right? So again, they can't be amended without a constitutional amendment, which is an incredibly difficult kind of thing. So that just, plays into how important it becomes. Okay, so let's go back a little bit of history. So the modern treaty process began in the 1850s with the Robinson treaties, touching on the Great Lakes. So, here's a map of Ontario. Robinson, Huron, you see it's above the pre-Confederation area there. That's what we're in. Sault Ste. Marie is in Robinson, Huron Treaty. And then, the next day, the Robinson Superior Treaty was signed. Again, this is with the Ojibwe people. And so these were the very first modern treaties. Modern treaties being they were no longer for peace and friendship. They were no longer for military alliances when the French and the British were fighting each other, and then the British and the Americans, the War of 1812, keep that in mind. They were no longer treaties for those purposes. They were treaties where, in fact, the Crown, the British Crown, intended to acquire land and to create Crown lands for the purposes of development and settlement, and created the reserve system that was embodied, in 1876, with the Indian Act. So this was the beginning of modern, what we call the modern treaty era, although they're considered in relative terms to be historic treaties because they're now 170 odd years old, right? So the Robinson, Huron, and Robinson Superior treaties, they created the template upon which the federal government would go forward and negotiate what are called the numbered treaties, the Great Numbered Treaties, and there's 11 of them. So you can see here, so Robinson, Huron, Superior down here, and then Northern Ontario, Manitoba, Saskatchewan, Alberta, the northern part of Quebec, and a great part of the Northwest Territories were all part of the 11 numbered treaties. They were entered into between 1850s, 60s, and 1921, basically. What these treaties did is they dealt with the cession of land. Cession means the acquisition of land, i.e. The Indigenous tribe would sign over any rights they would have to any, and ownership isn't the right term, but it's the equivalent of ownership in the English common law system. So, the Crown clearly owned, from a title point of view, all of the lands that became part of the treaty. The reserves were created. Again, the reserves weren't given to the Indigenous peoples to own, only to occupy. And that's still the case today. So in Garden River and Batchewana on both sides of the Sioux, those reserves are still owned by the Canadian government, but the bands have the right to possess them. That's the way the Indian Act works. Annuities were created. So the annuities, for instance, in the Robinson treaties was $4 a year. Now, $4 back in 1850-51 would have been a pretty good chunk of change. So it would have gone quite a ways for, and this belonged to every member of what became the band, and the band would have a list. The band council, had a list that was controlled by the Indian agent, again, a white bureaucrat, but they were entitled to annuities, and the thing is, they never changed. Even though the Robinson Huron Treaty was very specific and very well negotiated by the Ojibwe, which basically tied the amount of the annuity into the resource, the value of resources extracted on a yearly basis by the Crown, or by licenses the Crown would give to resource extraction. So there is a monumental piece of litigation ongoing right now between the 50 basically First Nations that belong to the Robinson Huron Treaty, suing the Ontario government and the federal government for back payment, because my son-in-law, again from Batchewana, still only gets $4 a year. Right, he still gets that $4 annuity, whereas now he's going to participate with probably 50 or 60,000 other members of the treaty in what the court decides is the value of those resources that were developed over the course of the last 170 years. So it's going to be a big deal. At this stage of the litigation, what's happened is that the court, this is the Superior Court of Ontario, has ruled in favor of the treaty people. It's ruled that clearly the governments did not honor the treaties and pay the amounts of the annuities tied to resources that they're supposed to. And so what's happening now is, all the economists come into it to calculate, to put a number value on what that loss actually means, which is going to be a tremendous amount of money. We're talking millions, if not billions, that the government's going to have to come up with to compensate for something they should have been paying for the last 170 years. So that's ongoing. So that gives you an idea of treaties and how they were negotiated a century and a half ago, but still have relevance today. Treaties also, these are again starting with the Robinson Huron Superior and the number treaties. They would describe the federal government's obligations under the treaty, and they would also provide, of course, with the continuation of Indigenous rights to hunt and fish on the Crown lands. So even though the band would end up being the First Nation would give up their territory and basically it became Crown lands, they still retained the rights to carry on traditional practices on those lands, and that's at the heart of almost all lawsuits going forward with respect to the Supreme Court of Canada deciding how to determine who has what rights on those lands. Okay, so right. So treaties now cover, again, most of Canada. We just saw that in the large number of treaties, with the exception of British Columbia and the Arctic. So there really wasn't, the reason it's not in the Arctic is there really wasn't anybody there. There wasn't a white settlement there, for instance, for anybody to negotiate with. British Columbia, interestingly enough, again, let's go back to terra nullius that's in place in Australia. So British Columbia, in fact, put terra nullius in place, the colonial government in that part of the country. That's the position they took, right? And so, that's why, back on the slide back here, right, there's a good chunk of British Columbia there that doesn't have a treaty on it. And so, now, again, just like in Australia, it's now come back to bite them big time, because now what they have to do is they have to negotiate treaties with peoples who are much smarter, who basically have lawyers who belong to the bands, the First Nations. They have their own lawyers. They can hire however many lawyers they want to challenge the government and negotiate these modern treaties. So, the government of the day 150 years ago thought they were getting away with something by not recognizing the rights of the Indigenous peoples and the territories, and now their ancestors are paying for it big time, and that's exactly the way it should be. Okay, court challenges, again, we're going to talk about some cases tonight, started in the Supreme Court from the 1970s going forward. Oh, Michelle, you raise your hand again?
Yes, I did. Wasn't it back in the day that it was illegal for Indians to retain lawyers? Like they weren't allowed to, yeah.
You're giving my lecture for me. So, actually the Indian Act 1876 made provisions in it that weren't reversed until the 1960s, that in fact Indians in Canada could not hire lawyers to represent their interests. And that again wasn't reversed until the 1960s. It's also when Indians were allowed to vote in federal elections. So, that's the dismantling of residential schools and the 60s scoop and all that kind of stuff. So it was a very transitional time. But, so for the vast majority of time, for the first 100 years that this country existed, if you were an Indian and you were being harmed by colonizers, the Canadian government, whoever it's going to be, you had no right to sue them. The right was actually, so that provision of the Indian Act was revoked in the 1960s. And so lawsuits started. And then what you happen to see is that, cases take usually 7 to 8 years from the time they start to get to the Supreme Court of Canada to be heard. So by the 1970s, we now start to see cases coming forward, basically where Indigenous peoples are now contesting the wording in the treaties that they're faced with, basically saying, look, the way this treaty is being applied is not the way it was originally negotiated. All right, and you remember, of course, that at the time of negotiations 150 years ago, again, Indigenous peoples were an oral society, so they relied upon interpreters that tended to be British, right? So they didn't always get a truthful statement as to what they were signing, okay? At the time of negotiation, of course, during the number of treaties, again, the 1860s to 1920s, it was imperative for the country to build the country. So that's why they entered into these treaties. They recognized that, in fact, they had to acquire these lands to allow for the creation of the provinces of Manitoba, Saskatchewan, and Alberta, and what have you, which all were originally Rupert's land owned by the Hudson's Bay Company. Right, so that was why the treaties were entered into, again, on a peaceful basis, but not necessarily an equal basis. All right. And Indigenous peoples, they entered into the treaties because they recognized the futility of not doing it. So Chief Shingwak, and he's very important at Algoma, and the Ojibwe people, he was a treaty chief. He recognized that there was no turning back this white tide of colonizers, in British North America, and so treaties became recognized as a way to basically, they were facing diminished resources. People were dying from smallpox. That was inflicted upon them by the colonizers. Intertribal warfare, whatever it was having. So they looked at treaties as a way to get some cash. And sometimes it wasn't a lot, but in modern treaties like Nunavut, it was $14 billion. So, it is adjusted for inflation. They were guaranteed annuities. The reserves were created. They were promised education facilities. Again, unfortunately, residential schools were part of that, but schooling was a guarantee the federal government provided, and a promise to transition them to agriculture, so to have a society that wasn't totally dependent upon hunting and fishing and trapping, although there were a lot of Indigenous peoples who were farmers before the white man showed up. In 1876, after the conclusion of the first 7 member treaties, right, so there was a real rush of treaties from Confederation for the next 10 years kind of thing. What happened was that after that rush, the federal government, again, John A. Macdonald, put in place the Indian Act. And so what the Indian Act was in 1876 was an amalgamation, essentially, of all the Indian laws, including the Royal Proclamation up until that point, basically. It confirmed the transformation of the relationship. Basically, it recognized that no longer was it a nation-to-nation relationship recognized in the Royal Proclamation. It was now a paternalistic one, right? Again, the one where, the government and churches thought that they could educate Indian children better than could their own cultures, right? They could make them little white people to, survive in a colonial environment, basically. That's very paternalistic, basically. So Indians were seen to be wards of the state. As a matter of fact, the federal government in 1867, when it created Canada, by putting, Indians into Section 9124 as a federal responsibility, did it without any negotiation whatsoever with any Indigenous peoples. They just basically took the proposition that we're creating this new country. Here's the obligations that the federal government's going to have, and one of those obligations is going to be, we'll take care of the Indians, right? So that's a very paternalistic thing in its own right, okay? Eventually, court cases, again, now we're talking, 100 years later, came, before the courts to enforce treaty rights, and the federal government took the position that originally that the Indian Act overrode these treaties, all right? So, the federal government certainly fought back in the early litigation with respect to rights that were being asserted, basically. Between 1899 and 21, 4 more treaties were entered into, so that was the end of the large number of treaties. And just like basically saying that you have no right to sue for anything, we're also not going to negotiate any further treaties. So from the 1920s to the 1970s, no further treaties were negotiated in Canada. All right. By the 1970s, by virtue of the Supreme Court, the federal court, again, Calder and Sparrow, we'll talk about those tonight, basically acknowledged that, in fact, Indigenous peoples had rights that were being trampled upon. And so the federal government, seeing the direction that the Supreme Court was going in, decided to recommence negotiating treaties. And they did it by what is called comprehensive claim settlements, which are now modern treaties, basically. The government of Canada now recognizes that relations with Indigenous peoples must be based on a recognition of self-determination and self-government. So again, as we talked earlier, the questions that it was Orette and Michael had, I think, and Tyler, that clearly Section 35 is there to make this a reality. And that's the direction we're going in. And so in very fundamental terms, reconciliation is the purpose of Section 35 of the Constitution. Likewise, and this is a function of Supreme Court rulings, the honor of the Crown is to guide all dealings with Indigenous peoples, which again includes Indigenous and fiduciary duties, basically. Indigenous peoples must have free and informed consent when the government proposes to take action that affects their rights, including their lands and resources. So that has become what's called the duty to consent and accommodate. We're going to talk about that a little bit later, basically. So here we have, this is just a way of overview for what we've just talked about. So we originally had peace and friendship treaties, right, which had nothing to do with land. It just dealt with basically military alliances and trade for the most part. You had the Treaty of Niagara in 1764, which is what in fact brought into place the policies of the Royal Proclamation of 1763. We have the Robinson-Huron treaties of 1850. We talked about those. Likewise, the 11 number treaties that ran from 1871 to 1921. Okay, so fast forward now, basically, at the end of World War II, 1945, the United Nations was formed. It was formed by the Allied powers at the end of the war, basically United States, Great Britain, China, France, and Russia. Those were, and they became the permanent members of the Security Council of the United Nations. They still are, which is a whole other class I teach, and lots of problems with that. But what the United Nations did, which was a coming together of the countries of the world, 193 countries now. They came together in 1945, and then, you know, within a couple of years, by 1948, they adopted the Universal Declaration of Human Rights, which is the precursor to all basically rights documents that exist, you know, around the world today, including the Canadian Charter of Rights and Freedoms, basically. What the UN also did is it created, you know, for the first time, a forum for peoples in various countries or states to have any complaints they may well have heard outside the boundaries of their country or state. So it provided a forum for peoples to go to the United Nations to complain, for instance, Indigenous peoples to complain that the government of Canada wasn't treating them fairly, right? So that's international law. We're gonna talk a lot more about that in Thursday's class, right? So prior to 1960, Aboriginal rights in Canada were seen only as those in the Indian Act, in place since 1876. And this brings us to 1969, and I mentioned this a little earlier this evening. It gave us the white paper. So the white paper was put forward by Pierre Trudeau. He was elected Prime Minister in 1967. Pierre is obviously Justin Trudeau's father. He put the white paper forward in 1969. His Minister of Justice was Jean Chrétien, who became our Prime Minister in 1993. But having said that, the white paper, the purpose of the white paper was to do this. It was to recognize the equality of Aboriginal Canadians by revoking the Indian Act. Basically saying that the thought was, if we completely revoke the Indian Act and all the systemic racialized provisions of it, the paternalism in it, if we get rid of it, then Indians are equal Canadians. They're no different than any other Canadians. The problem with that was that it was done without any negotiation or discussion with Indigenous peoples in Canada at the time. The Indian Act, as racialized and paternalistic as it was, certainly still did provide for things like the annuities and tax benefits if you had status. You know, there were things in the Indian Act that were put there to basically compensate Indigenous peoples for the loss of their territories. So, you know, there was a great deal of protest to the White Paper in 1969 by Indigenous parties, basically. So it was very much opposed. It saw the removal of special rights and obligations and the termination of their status, which has value to those who in fact are status Indians under the Indian Act. And it led to things like political activism in the 60s and 70s and the creation of the Assembly of First Nations, which still exists in Canada. All right. Again, 1960s, cases started to be heard by the Supreme Court regarding things like hunting rights. So the Calder decision in 1973 in the Supreme Court of Canada basically held that Aboriginal Canadians possessed rights over traditional territories, and that right has not been extinguished by Western occupation and the history of colonialization. Right, so that was really the very first case in the Supreme Court of Canada. Again, the 1960s was the first time they had the right to bring a lawsuit, so it took that long to get to the Supreme Court. And Calder, it basically recognized the rights of Aboriginal Canadians, that they had these rights over their traditional territories. As a function of that decision, again, this is the first time the Supreme Court has said to the federal government, look, you can't ignore the rights of these peoples in this country. Then the federal government and the provinces started looking at negotiating settlements rather than lawsuits. You know, certainly they saw that as the way to go. What that ended up with is what's called the very first modern treaty in Canada. It's the James Bay and Northern Quebec Agreement of 1975. And what that was a negotiation between the province of Quebec. Now, it's interesting that it was the province of Quebec because, again, the Royal Proclamation, which was in place in 1975 as a function of the Constitution Act of 1867, basically said that only the federal government could do this kind of treaty negotiation. But at the time, in the 1970s, there was a lot of problem with politicians in Quebec. Quebec itself was talking about seceding from Canada, leaving it and creating its own country. So the federal government turned a blind eye to the fact that Quebec was going to negotiate this treaty. And they did. And what they did is negotiated a treaty with the Cree in northern Quebec and the Inuit, the indigenous peoples of the Arctic in northern Quebec, the Arctic Circle, to acquire the territory to create the James Bay hydroelectric plant, which is a monumental moneymaker for the province of Quebec. It is the economic engine of the province of Quebec even to this day. It still sends most of its power to Upper New York State, and they get paid big money for that. But as a function of that, in this treaty, in exchange for the indigenous peoples giving up their territory and getting money for that, and giving up their lands and what have you, they actually got the provision for self-governance. First time this ever happened in a treaty. So, they were allowed to create their own systems in place for police, education, healthcare, and importantly, for the purposes of our class, environmental assessments, which, in lands, particularly the Arctic, are incredibly important because the ecosystem is so fragile. So 1975 was the first modern comprehensive land claim agreement in Canada, and it became the model for further claims. So it became the template going forward. What it also did is, for the first time, it also gave Indigenous peoples participation in the resource extraction that was going to take place with licenses granted by the federal government, or in the case of James Bay, the Quebec government, including profits from resource extraction, including the hydroelectric dam. And so that's really important. So again, we're talking about now the evolution of treaties that allows for some self-determination and allows for profit participation in resource extraction. So to actually make money going forward. It also makes provision nowadays for hiring of Indigenous peoples for subcontracting jobs, truckers and people who build roads, construction workers, all kinds of jobs. Indigenous peoples in the territory in new treaties, comprehensive land claim agreements, get basically the first right of refusal to take on those jobs, which is obviously very important. Okay. If there is a treaty, for instance, like the Robinson-Huron Treaty, that is disputed, we have a system in Canada called the Specific Claims Policy that's put in place by the federal government. So the lawsuit between Robinson-Huron Treaty people and the government is a specific claim. That's what it's called. And so the government pays for arbitrators to hear these claims. We have arbitrators that actually live in Sault Ste. Marie for this purpose. And it's very important for them. And what they essentially do is they interpret treaties to ensure that they're properly handled, or that they're properly interpreted, and all rights are given to the peoples who entered into them. The Sparrow decision, which you also have, it's on Moodle and it's in your text, was the first time that the Supreme Court of Canada recognized that Indigenous rights were those under Section 35 of the Constitution, and those rights were to have the same authority as if they were in the Charter. Okay, so again, that's incredibly important. So Indigenous rights in, in territories, treaty rights, and inherent rights for hunting and trapping, those rights are constitutionalized and they're charter driven, which means that they have as much authority as, for instance, the right to be presumed innocent until proven guilty, as a charter right in the criminal justice system. So that tells you how pervasive these rights can be, right? So that's really important. What are Aboriginal rights? Okay, so basically Aboriginal title to lands and to rights does not permit activities that are incompatible with traditional activities in which historical occupation of the land is based. And it is a very historical analysis. But what this simply means is that on lands that are the subject of Indigenous or Aboriginal treaty rights and what have you, that nothing can take place that adversely affects the traditional use of those lands and territories. Traditional being the lands and territories as they were used for the most part at the time of British or French contact in the 17th century. So again, these rights are Indian activities exercised by Indigenous peoples at pre-contact or the time of sovereignty, right? So it's a very historical analysis. The 1997 decision in the Supreme Court of Delmagook, incredibly important decision. For those of you earlier this year and last year who were paying attention to the claim of the Wet'suwet'en hereditary chiefs in Alberta, who are putting a stop to the Trans Mountain Pipeline and the Mohawk protests in Ontario, all of these rights that were being put forward by the Wet'suwet'en hereditary chiefs were being put forward on the basis of this decision, the Delmagook decision of 1997. This is what the hereditary chiefs hung their hat on. And what that decision basically says is that Aboriginal rights flow from two sources. One, the prior occupation of the land by Indigenous peoples, again, constitutionalized as a function of Sparrow by Section 35, and the recognition of pre-existing Indigenous systems of governance. All right, and so what that means is that Aboriginal title is the exclusive use of a given territory, right? And that's the argument the Wet'suwet'en hereditary chiefs used, that this pipeline to be built, across northern Alberta, going through British Columbia to the Pacific Ocean, right? It's going through our territory, and we have the exclusive right to say whether it goes or it doesn't go. Okay, so all of those protests and all of the blockades, everything that took place over the course of a 2 or 3 month period earlier this year was a function of this decision. It's important also to recognize that Section 35, not only does it recognize the rights that existed as at 1982, and remember that Section 35 says in the wording itself, existing rights, but existing can mean rights as long as they evolve over time and they haven't been extinguished, right? So the manner of hunting, trapping, and fishing and what have you can evolve, as those kind of things do, as things modernize. They can likewise be constitutionalized and be protected as long as at no time were they ever extinguished, either by the band itself or the tribe itself or by the government. The Chilcotin Nation decision, I've given you this decision on Moodle as well, 2014, it basically says when rights are the subject of litigation, so this is clearly where some Indigenous group is taking a position that their inherent or traditional rights are being abridged or abrogated, then the burden is on them to basically protect those rights, to seek protection of those rights. In order to do so, they have to provide historical evidence to basically indicate when the rights existed. So here's what the court said. The practice, this being the Indigenous practice, in question must be of fundamental importance to the Indigenous society in question and must not be merely accessory. The practice may have evolved over time, but it must not have appeared only following European contact. It is not necessary that the practice be unique to the people before the court, as long as it constitutes a characteristic element of the culture of the people. And as a function of that, therefore, every trial, and I talk about this, I do an entire course on treaty rights, every trial that involves an Indigenous peoples trying to protect their rights, what they have to do is they have to hire historians to come to court and basically put before the court historical evidence as to what they actually did, what their rights were, hunting, trapping, fishing, what have you, as at the time of British contact, right? That's a monumental expense to go to, but the Supreme Court requires it. And that hasn't changed. What happens, of course, is that the Indigenous group will bring a historian to court to say, here's what the practice was. And if they're fighting the federal government, which is almost always what they do, sometimes the provincial government dealing with resources, if they're fighting a level of government in court, the government that's in court, they will also bring their historians to court to give their evidence as to what that particular Indigenous right or practice was at the time of contact. And as I said earlier, history is subjective, it's not objective. So what you basically have are dueling historians. You have two historians who are supposed to be giving you the facts of what took place in 1670, for example, and they'll give different answers. You know, one will say, here's what the practice was based on my historical research. The other one will say, no, my research says it was this. And then it's absolutely up to the judge to decide which historian he or she believes. And you know, almost universally, historians now, or the judges now side with historians putting forward the Indigenous position, right? The protection of Aboriginal rights, so I've told you what they are. So in order for a right to be protected, it must again not have been extinguished. And this is important, the state cannot justify infringing it. So it's important to recognize that, you know, even if an Indigenous group does have a constitutionalized Section 35 right to fish, hunt, or trap, whatever that right may well be within the territory, it can be extinguished, right? And if it's going to be extinguished, you know, it's going to have to be extinguished either voluntarily by the Indigenous peoples over the course of the last 2-3 centuries, or it can be extinguished by the government, right? They can intentionally extinguish a right. So that's important to know. And what Calder said in 1973, as part of the decision we've already talked about, is that in order for that to happen, the level of government who's trying to extinguish an Indigenous right has to do so by passing a statute. They actually have to pass a law expressly saying that we, in clear and plain English, are extinguishing this very particular Indigenous right. And the Vanderpeet decision, again in the Supreme Court in 1996, basically says that in order for that to happen, Parliament has to have recognized the existence of the right and has had to deliberately choose to extinguish it, right? And only Parliament has the right to do that. Provincial parliaments can't do that, okay? Prior to Confederation, of course, that wasn't the case because we didn't have a federal government. We only had the colonies of New Brunswick, Nova Scotia, Quebec, and Ontario. So they could have extinguished rights that had been put in place maybe 100 or 200 years earlier, right? But after Confederation, only the federal government. And actually in real terms now since 1982 and the constitutionalization of these rights, it's almost impossible to extinguish a constitutional right, okay? Matter of fact, most federal statutes that are passed nowadays actually have a very specific clause in the preamble saying that under no circumstances is this statute intended to abrogate or derogate from any existing Aboriginal treaty rights, right? So they're very much protected now. Okay, Sparrow in 1990 basically is a decision that says that when there is prima facie an infringement of a right, okay, which basically means that, you know, that somebody has come onto the lands of Indigenous peoples for the purposes of, you know, basically what becomes an interference with their rights, that, you know, the Indigenous peoples have to basically prove that their rights are being infringed, okay? And if they do that, you know, the court will decide whether or not that infringement is sustainable. So the Supreme Court has found, for instance, that rights have been infringed or not infringed. For instance, the obligation, if a government puts in place an obligation to hold a license to fish or hunt, that's not an infringement on a traditional right to hunt or fish, right? So governments have the right to require licenses for that purpose. They can impose an obligation to declare one's catch, fishing, for instance. They can pass laws with respect to the safety of firearms, again, deals with Indigenous hunting rights, basically. The Supreme Court has held that governments have the right to infringe upon Indigenous hunting, trapping, and fishing in this regard, kind of thing. But it has also held that when it tries to do things like put restrictions on how much can be caught or to limit Indigenous peoples on what species they're going to hunt or fish, or impose a season, right? So everybody, you know, who hunts and traps, you know, moose, deer, whatever, there's a season for it, you know, that you get a tag for a moose and those kind of things. Doesn't apply to Indigenous peoples, basically. And they can't impose fees for the granting of a license. So, you know, those are the kind of things where, in fact, while some limitations on hunting and trapping and fishing can be put in place primarily for conservation reasons, but the actual manner of hunting and fishing cannot be infringed upon, basically. If an infringement has been proven, then the state has the burden of justifying it, so putting in place those kind of rules. So it's a two-part test put forward in Sparrow. So the two things the state has to do if it's going to justify an infringement, for instance, requiring Indigenous peoples to, you know, basically declare their catches, the quantity of their catches. So in order to validate that, which is an infringement of a Indigenous right to fish, for instance, anything that limits that is an infringement. But the state, the federal government, in order to justify it, has to basically show that there's a valid purpose for this infringement. And does that infringement respect the honor of the Crown and the fiduciary relationship owed by the Crown? So that's the two-part Sparrow test. This is a really good exam question, by the way. And the purpose of it, basically, the purpose of justifying the infringement is that it has to be important enough to be recognized as clearly justified. So there must be a specific objective to that justification. So usually what is happening is the state is arguing the position. For instance, if it's granted a license to a resource company to be on the lands of Indigenous peoples, if they've granted a license, this is activity that's basically acknowledged by the state, and so it has to prove the right to do it. So the kinds of things that will allow this right to be infringed is, again, conservation of fish and wildlife. That allows for infringement of Indigenous rights. If safety is relevant, that relates again to the firearm kind of thing. If there's a overall comprehensive development of agriculture, forestry, mining, and hydroelectric power, i.e. James Bay, that has a very wide societal purpose to it, then infringements can be allowed for the most part, but in real terms that doesn't happen anymore because negotiations take place rather than litigation, or the building of infrastructure, things like sewers, waters, and road, that kind of thing, basically. To justify an infringement, the courts look at the severity of the infringement, and it's on a sliding scale, right? So the state recognizes that Aboriginal rights have a priority over non-Indigenous persons. So, you know, it's really only important, significant things that will allow for infringements. So, you know, if the state takes measures for the conservation of resources, it has to basically also make sure that the Indigenous people's sustenance needs are met, and that's a fiduciary responsibility. So they can't infringe rights that take away anything that's for the good of the Indigenous peoples. All right. Again, modern treaties took place, started with 1975. So I'm going to show you a 9.5-minute video of the negotiations dealing with the Cree people at the time of the St. James project, and then we'll return and finish the slides. There's not a lot more, so hang in there, guys. Okay, so let's watch this. Oh, hang on, sorry. I'm still learning this, right? I've got to stop sharing that. Share the computer sound. You wouldn't have been able to hear it otherwise. Now let's go.
Thus, the James Bay Power Development, which he said his government is going ahead with. The James Bay development involves greater power potential than the present Labrador development, a deep-sea port, drastic changing of rivers flowing into the bay, and a spin-off that includes mining development. Its estimated cost is $6 billion.
The Crees were excluded from economic development in the territory, from governance of the territory, from administration of the territory. Everything was decided by non-natives in the South.
My phrase at that time was, let's give our people a way of life that they have known all their lives. And that's the traditional way of life. The life to hunt, fish, and trap. Yet at the same time, give them a life an opportunity to enter into the modern industrial society if they want.
I remember when Robert Wawasa was interviewed, and one of the people said, "Well, what about those Indians living in the James Bay project? Did you consult them?" He says, "No, we didn't have to." He says, "Well, we're just to give them a welfare check, and they're not going to say anything after." But he was wrong.
There wasn't a single Cree who wanted a hydroelectric project. But we were faced with the reality that a project of some kind was going to eventually be built, with or without our consent.
The governments always told the Crees, you have no rights. You are squatters.
We're not going to go around trying to prove that we own it. It's up to the people who are invading it to try to disprove our ownership.
What Quebec did was it enacted a statute which in effect made the north of Quebec, which was the Cree and the Inuit territory, traditional territory, it almost made it a special colony under the control of this corporation called the James Bay Development Corporation, and that was Bill 50. And what that gave the board of directors the power to do was to develop natural resources essentially as it saw fit.
Hydro-Quebec and Quebec government were about to embark on what the people considered the destruction of their land, their river, their way of life, their culture.
Mr. O'Reilly, I said, I'm Chief Billy Diamond from Waskaganish. I said, I have something in mind. I have a court case in mind that's about to make you very, very famous.
It's the last frontier to open in North America, and we cannot afford to make too many mistakes.
Chief Billy Diamond, at one time the youngest Indian chief in Canada, explains the project to his people. His home, Rupert House, will be the last stop on the trip.
The land was never won in battle. The land was never given away. The land was never surrendered. So the only thing that happened was the land was stolen, and what is stolen must be returned. The showdown must come between the province and the Indian. It must come.
He worked all of November to prepare legal proceedings against the government of Quebec, the government of Canada, plus all the Crown corporations like Hydro-Quebec and James Bay Development Corporation, James Bay Energy Corporation. We put them all in one package. We did not differentiate. We put them all in one package, Then we said, okay, we'll sue them all. We'll go to court.
The Indians and Inuit of northern Quebec in December 1972 went to Superior Court in Montreal in an effort to bring the giant project to a halt.
It was an 11-point offer. It was a $100 million offer, and we were not happy with it. It did not contain the issues that we wanted to see. And we said, no way, no way. So we're walking out of here today, but we're not going to have an agreement today. We're walking out of here with our heads held high.
We govern ourselves the way we want to in accordance with our own customs, our own laws, and our own ways.
Rights with regards to hunting, fishing, and trapping, that to the greatest extent possible, that we should continue and maintain those rights which we had before, whether they were recognized or not.
We finally began to hear, what else do you want to discuss? What else can we do?
Control over education, Crees running their own education, control over health and social services.
And I said, Mr. Chacha, how about categories of land? Small piece of land, we'll call it Category 1.
Category 1 were the actual land of the communities in total control of the Crees.
Category 2 will be for the exclusive use of the Cree for hunting, fishing, and trapping.
The government would not be able to reduce that area and would have to maintain it forever.
And Category 3 would be the other lands outside of that, as long as you recognize the Cree rights.
Category 3, it's also subject to development, but the Crees can hunt, fish, and trap, and there can be some non-native hunting and fishing, not trapping. The Crees have the exclusive right to trap throughout the Cree territory.
The Cree people first opposed the James Bay Hydroelectric Project because they felt that their way of life was threatened. Since the announcement of the project, we have gone through a court action, and now we have finished negotiations, and we are prepared to sign a final agreement.
Well, I had mixed emotions. Mixed emotions were, have I done the right thing for the people of the Cree Nation? Are they going to be better off, or are they going to be worse off?
But I knew that deep down this was the right thing for the Cree people. I knew that this was going to be the catalyst that was going to push us forward.
Okay. All right, guys. All right. So back we go. Not too much longer. So, all right. Okay. So modern treaties. So modern treaties again are the ones that started with that James Bay Agreement. So they're much more than what was contained in those original 11 large numbered treaties. There we go. Wow, almost like I knew what I was doing. Okay, all right, guys. So let's continue. So these are the things that are in modern comprehensive land claim agreements. They deal with the use of lands, which includes now actually includes the title to some lands going to Indigenous peoples. So that's diametrically different than what was contained in original treaties, where all lands belong to the Crown. Rights include obviously traditional rights to hunting and fishing and resource extraction, basically participating in resource royalties, incredibly important. Again, environmental assessments, economic development, preferential employment. I talked about that earlier. Basically, Indigenous peoples, get to do the construction on the sites, especially for large construction projects, and again, provisions for self-governance, which is a monumental move forward. All right. One of the things that is incredibly important when it comes to Indigenous lands and anybody who is going to be dealing with any activity on those lands going forward is what's called the duty to consult and accommodate. This is, again, a duty that's given rise as a function of the Supreme Court of Canada. So it was developed in these particular cases, Sparrow, Vanderpeet, and Delmagook. So I've given you Sparrow and Delmagook on Moodle, I believe. All right. What it does is it protects Indigenous rights, but there are some issues with it. It's reactive in that it usually only becomes an issue because somebody has done something that has imposed or infringed a right that somebody complains about. The burden is on the Indigenous peoples to establish their historical rights. We've talked about that. And the remedies to address them are fairly limited with respect to the jurisdiction of the Supreme Court. Haida Nation in 2002, again, the court indicated that the state, and this is addressing the issues that we have here, Supreme Court in 2002 basically said, look, when it comes to the DCA, the duty to consult and accommodate, it's got to be better. It's got to be, again, symbolic of the honor of the crown. So the duty to consult and accommodate Indigenous peoples must take place at all stages of resource development on Indigenous territories, including the stage of the contemplation of a project. So, the very idea of something taking place requires consulting the Indigenous peoples that are going to be affected. So it is in place, before any authority is going to be authorized, or any activity is going to be authorized. So again, it's constitutionalized as the honor of the crown, basically. Elements of the DCA include the following, and includes assessments of environmental and social impacts of projects and proposals for co-management of resources. That's incredibly important. What it basically is saying is, to a great degree, they partner with Indigenous peoples when their resources are on the table. And 2, IBAs, that's short form for impact benefit agreements. So what they basically are is what happens now in virtually all cases where any company, a resource extraction company dealing with timber or water or species, fish, whatever it may be, minerals basically are really important. Any company that wants to basically get involved with any of those activities on lands that are traditional territories, which is basically most of Canada, because they're, the treaties cover so much of the country. Anybody who wants to do that, they have to enter into what's called an impact benefit agreement with the First Nation that is basically the treaty people for that territory. And those agreements, again, are now contracts that are entered into between the Indigenous peoples and the resource company. So the federal government delegates its authority to the resource company to deal with the Indigenous peoples, to deal with all those things we just talked about: resource extraction, first rights of refusal for construction, education rights, all kinds of things, all kinds of benefits going forward are now contained in impact benefits agreements, basically. Consultation is ongoing, so it starts from the time a plan is put forward to the actual construction and the operation of activities, basically. So it's certainly there for anything that goes forward in a land use basis that's permanent, which is a great many of these resource companies' purposes. When does it give rise? Basically, only when there's a potential infringement of a right or a treaty protected by Section 35. Okay, so all those constitutional rights put in place that were existing as of 1982 going forward, those are basically the only rights that give rise to a DCA. So the federal government can now exercise this duty when enacting legislation that affects Indigenous peoples. It can apply to policy decisions. So the federal government, if it's putting in place a policy that's going to affect Indigenous rights, which includes policy statements, manuals, directives on land uses and allocation of resources, the DCA obligation applies. Okay. Importantly, however, there is no duty to consult and accommodate for past wrongs. So if somebody has come in and done something and it's already taken place, then the opportunity for consultation is lost, right? And there's no remedy for that. So, you know, that's why the court has made it very clear that the duty arises when something first takes place, certainly not after it becomes historical. Large development projects are subject to a number of approvals involving a number of government bodies. So the DCA is applicable at all these levels of activity. So for instance, a pipeline project, firstly, you need what's called a Certificate of Public Convenience and Necessity issued by the National Energy Board. That triggers a DCA. The location of pipelines subject to further approvals by the Energy Board, again, accommodation and consultation. Environmental impact studies by the governments, again, DCA. Construction permits, DCA. All of these stages are all, you know, they all attach to them the requirement to consult and accommodate Indigenous peoples on the territories for which they historically now have constitutional rights to hunt, fish, and trap. It can't be delegated, basically, other than to those companies that you know, are given licenses by the federal government. So again, that's a continuation of what originally King George III said in the Royal Proclamation, basically. It ensures effective consultation and guards against conflicts that may give rises, basically. Private parties, again, don't owe an obligation for DCA unless the federal government says that that's your obligation if you want to, in fact, get involved with resource extraction on these territorial lands. All right, guys, so that is it for the lecture on treaties. So I think you've got a really good idea of historically how they came into existence, how they evolved over time. They went from peace and friendship. They then evolved into treaties that involved lands, like the Robinson-Huron treaties, which then became the template for the 11 numbered treaties. Then we had 50 years or so where there were no treaties, and then we came back to, you know, activity by the Supreme Court in the 60s and 70s, recognizing the right of Indigenous peoples and how they were improperly dealt with treaty rights, which basically then prompted the federal government to enter into negotiations with what became comprehensive land claim agreements, modern treaties, to ensure that Indigenous rights were in fact protected. So, you know, the system now in place for, and again, now for the most part, these apply to British Columbia because, you know, it didn't have treaties historically. Most of these comprehensive land claim agreements are negotiated there. And now it deals with all kinds of issues, as we now know, dealing with things like pipelines and what have you, which tend to be in the news all the time. All right, so that's it. So let's go into the breakout. It was a longer class. It won't be this long Thursday night when we deal with international law, I promise. But again, I thank you, everybody. Your participation is fabulous. I'm just tickled pink about how well everybody's doing in that regard. So it's just super. I'll post tomorrow the breakout questions for Thursday's class, and then post the PowerPoints as soon as I can. I'll also post on Moodle tonight the recording of tonight's class. All right, guys, thank you very much. Have a great night, and I'll see you on Thursday.
Thanks, sir. Bye.
Thank you. Bye-bye.